All right, we are on the record in file 22-21115-FH and 22 I'm sorry, this is both just 22-21115-FH, People versus Dante Roy Taylor. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
A.V. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Taylor.
All right. We had a hearing last week regarding a new piece of evidence. I issued an opinion and order which granted the people's motion but vacated the trial date in order to allow the defense time to deal with that issue. And so at this point, we need to set a new 2-day trial date. Mr. Dagger Margosian, I guess I'll ask you, how much time do you think you need in order to investigate this and prepare?
Your Honor, it probably will require some type of written motion specifically on the issue that was just addressed. So, probably including that as well as the trial date. We may be looking at, I don't know, a few months, certainly, maybe 4 months at this point. I don't know what the court's, the rest of the trial docket is like, but that's what I'm thinking.
You know, I mean, given the age of the case, I'm willing to move some things around to get this back on calendar as soon as possible. But, you know, I also want to be sensitive to the fact that you just had something, a new issue dropped in your lap that you've got to investigate. So, you know, I'm willing to work with whatever timeline you think is appropriate.
Yeah, I appreciate that, Your Honor. I like I said, I do think there probably will have to be further argument as to the admissibility and relevance and that sort of thing, which is really not appropriate to get into right now. But I do think it would be appropriate to at least, on my end of things, to file something for the court to review. And in addition with that, with the trial, I think we're, like I said, it may be, I would ask for, I don't know, 3 to 4 months. I mean, that's what I'm asking for. And there may be other motions to bring up in this case. So that's just my end of things.
Okay, so that would take us into like the end of May or the first part of June. End of May would be 3 months. June would be 4 months. So let's see, Ms. Clark, if you are there, do we have any 2-day trial dates available, say in the end of May, first part of June?
The first available is looking like June 20th, but that'll be backed up to a jury trial.
What trial is that?
Donald Lester.
Okay. Would you mind, Francis, bringing the book into me?
Yes.
And just for my 2 cents, I have about 11 witnesses, and I've spent the last week compiling all of their dates that they are unavailable in the next 6 months, just to try and make sure we're not going to have any sort of conflict. And that date does, you said June 20th, that date does work for all of them. It is not one of the blackout dates that I was given. In addition, I would just ask that if Mr. Dagger Margosian is going to file a motion, that the court make the motion deadline at least 30 days before trial, just so that I can comport my proofs with whatever ruling the judge or this court gives us.
Your Honor, I'm looking at the calendar. If this is certainly be more than a 1-day trial, and I'm unavailable the 21st.
How about June 25th and 26th?
That works for us.
Yes, I think that works as well.
So the 25th would be 9 a.m. 10:30. 11 witnesses sounds like a lot to me for 2 days. Do you think 2 days is still a sufficient amount of time?
I mean, I hope so. I don't know. It's hard to say.
I,
And I don't know
I,
if defense has any witnesses, but
I agree with the court that may be tight.
so I know some are short, but some are a little bit lengthier.
All right. Do we have the ability to add the 27th?
That should work for me. There's one witness who it's actually my OIC. He listed an unavailable starting the 27th, but I think he would make himself available if we went past the 26th. If that's obviously the best we can do.
Okay, let's tentatively set it for that then. If there is any issue, Ms. McClurkin, let us know as soon as possible so we can figure out what we need to do as an alternative.
I can do that. Yep, I'll call him as soon as we're done. Other than any potential motions, I guess I just would like to place on the record that I've made a new, excuse me, a new plea offer to Mr. Taylor. So I just want to place that on the record and indicate at this time that people believe we filed all jury instructions, voir dire and a verdict form that obviously comport with the amended offer or the amended information as it stands. So I believe we're ready for trial. Otherwise, have complied with that scheduling order. Again, I would just ask the court set the new motion deadline at least 30 days before, where we would hear them at least 30 days before. And the updated plea offer in this case is that Mr. Taylor would plead to reckless driving causing death and OWI first. His guidelines on that being 19 to 38 months with no a Killebrew agreement, excuse me, to no Michigan Department of Corrections time. So a jail sentence that would be below his guidelines. And alternatively, the guidelines on the offense as charged start at 29 to 57 months.
Your Honor, I've reviewed plea agreements and sentencing guidelines. At this time, we're moving forward with trial. If that changes, we'll let the court know.
Okay, so we'll have trial dates then June 25th, 26th, and 27th. Let's do a final pretrial conference on June 12th at 8:15. That would make a motion deadline of May 29th to be filed. And at this point, we'll set the bond hearing or the violation issue for the day of the final pretrial, that'd be June 12th. All right, is there anything else we'd like to address in this matter this morning?
Nothing on behalf of the people.
No, Your Honor, thank you.
All right, thank you for your time then. Court will issue a scheduling order. Mr. Taylor, you can go ahead and log out.
Thank you.
Thank you. Okay. Ms. Underwood, are you ready to proceed with Mr. Olds?
Yes, Your Honor, thank you.
Okay. We are on record in file 23-21535-FH, People versus Brian Douglas Olds Jr. We are here today for a final pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bandit.
Rhonda Underwood for Mr. Olds this morning, Your Honor.
Mr. Bayonetto, if you said anything, I was not able to hear you. Not getting any audio from you. Okay. I think Mr. Bayonetto indicated that he was going to come upstairs to the courtroom.
Judge, were you waiting on me? I'm sorry.
No, we were having an issue with Mr. Bayonetto's audio.
Oh, okay. I'm sorry. I was on the phone with.
Okay, I did send you a chat regarding one of the other defendants to see if you can cover that or if we need Ms. Arnold.
Nope, I can cover that. She left me all her notes.
Okay.
If you got the arrearage paid off, they would dismiss the case, but you know what your arrearage is? Well, how many kids are you paying child support on?
All right, Mr. Oldham, have you sit back in the gallery where you were. We're going to do another case while we're waiting on Mr. Bayonetto.
It was working yesterday.
How do you pay child support for other children? Where do you work at?
Okay, Ms. Underwood, I need you to either shut your door or put yourself on mute because we're hearing Mr. Milaro talking to his client.
One moment.
Can you spell it?
All right, good morning, sir. You're Mr. Berger Ellis?
Yes, sir.
Okay, Mr. Daly, we can proceed with Mr. Berger Ellis's case.
Ready, Greg?
So you've only been working there about 3 months.
This is file 19-19274-FH and 24-21706-FH, People versus Michael Henry Berger Ellis. We are here today for a pretrial conference in the 24 case, a probation violation hearing in the 19 case. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure for the people.
E.B. McClure on behalf of the people.
Tim Daly on behalf of the defendant, Your Honor.
Okay, and Mr. Daly, where do we stand with Mr. Berger Ellis's cases today?
Your Honor, we have a plea bargain agreement in this matter where the defendant will plead guilty to count one with the remaining charges being dismissed at the time of sentencing. There is an agreement that under the plea agreement that the sentence shall be a minimum sentence of 5 years, with the other charges, again, being dismissed at the time of sentencing.
Okay, and then what is Mr. Berger else going to do with the probation violation? He's going to plead that.
He will be pleading guilty to that, Your Honor.
Right. All right, Mr. Berger Ellis, would you raise your right hand, please?
Yes,
Do you
sir.
swear? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Michael Henry Berger Ellis?
Yes, sir.
You can put your hand down now if you like. Mr. Berger Ellis, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, child sexually abusive activity?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $100,000 fine?
Yes, sir.
Is it also your intention in file 19-19274-FH to plead guilty to the probation violation?
Yes.
Do you understand that in that case, you had pled guilty to assault with a dangerous weapon, and the maximum penalty for that offense is up to 4 years in prison?
Yes.
Are you satisfied with Mr. Daly and the advice that he's giving you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed it on the record here this morning. Is that correct, Ms. McClure?
That's correct.
Mr. Daly?
It is, Your Honor.
Is that also your understanding, Mr. Berger Ellis?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Berger Ellis, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir. I understand.
Do you also understand that any appeal from this conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand those rights?
Yes, I do.
Okay, and so those are the rights that apply to the new felony case. With respect to the violation of probation in the other file, you have all of those same rights, with the exception of you have a right to be presumed innocent until your guilt is proven by a preponderance of evidence with respect to the probation violation. Do you understand that?
Yes, I do.
And do you understand that you have all of the other rights that I explained that apply to the new felony case as well with respect to the probation violation?
Yes, sir. I understand.
How do you wish to plead to, in file 24-21706-FH to the charge that on or about December 17, 2018, in Madison Township, Lenawee County, Michigan, that you did commit the offense of child sexually abusive activity?
Guilty.
And how do you plead to the charge that in the 19-19274-FH, to the charge that you violated the terms of your probation by being arrested on September 13, 2023 in Madison Township for various counts of criminal sexual conduct?
Guilty, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir, I understand.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Berger Ellis to plead guilty?
No, Your Honor.
None, Your Honor.
Mr. Berger Ellis, other than as we've discussed on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just 5 years or whatever.
Okay, just what we've talked about on the record this morning?
Yes.
Is it your own choice to plead guilty today?
Yes, it is.
All right, Mr. Daly, would you like to cover the factual basis?
Yes, Your Honor. Mr. Ellis, between December of 2018 and August of 2023, where were you living at?
276 Tiffany Street, Adrian here.
Is that in Madison Township?
Yes.
Okay. And in that period of time, did you engage in child sexually abusive activity?
Yes.
Did you engage with some individuals on the internet that you thought were young girls?
Yes.
And they weren't young girls, were they?
No.
They were older people pretending to be young girls. Is that right?
Yes, it was.
But you thought they were young girls. Is that correct? And you asked them to send you pictures. Is that right?
Yes.
And did they send you pictures?
I
Did
no,
you-
they did not.
Did you receive pictures of nude children?
Not from the internet one or whatever.
Okay, who did you receive those pictures from?
Tasha Gonzalez.
I have no other questions, Your Honor.
And that individual with the initials TG, she was in fact, would it be 11 years old?
I'm sorry, Mr. Berger Ellis, if you responded, the mic didn't catch your voice.
No, I didn't say anything.
Was she 11 years old?
When we first started talking, yes.
And did you ask her to send photos of herself?
Yes.
And were those photos sexual in nature?
Yes.
People are satisfied, Judge.
Mr. Berger Ellis, with respect to the 19-19274-FH file, you were placed on probation back in July of 2019. Is that correct?
Yes, it was.
And in the file is an order of probation. It was signed by myself, and under that, there's a line for the defendant's signature. There's a signature on that as well. Did you receive and sign a copy of your order of probation?
Yes.
One of the terms of your probation was that you not engage in any criminal activity. Is that correct?
Yeah.
All right. And you would agree then that you did in fact just plead guilty to a new felony offense. Is that right?
Yes, I did.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. McClure?
Judge, did we go over the fact that he was gonna have requirements under the Sex Offender Registration Act? Which I think he already does in her first
No, I
prior offense.
don't think that I mentioned that. Mr. Berger Ellis, do you understand that by entering into this plea, you will be required to register under the Michigan Sex Offender Registration Act?
Yes, I understand.
Thank you, Judge. And yes, the people believe you have satisfied the requirements.
Mr. David?
I have nothing else, Your Honor.
All right. And Mr. Berger Ellis, with that understanding that you're going to be required to register under SOAR, do you still want to proceed with entry of this plea?
Yes, I do.
Right. I will accept your plea then. Your pleas, they have been given understandably, voluntarily, and accurately. Mr. Berger Ellis has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. Could you go grab my yellow paper? Yeah. I will refer this matter to the probation department for a pre-sentence investigation, and if you hold on just a moment, we will get you a sentencing date. Set sentencing for April 5th at 8:15 a.m.
Okay.
Your Honor.
All right. Thank you then, Mr. Berger Ellis. You're all set. You can let the officers with you know that you're done with court for today.
Okay, thank you.
Okay, Mr. Olds, do you want to come back to the podium, please? All right, back on the record in People versus Brian Douglas Olds Jr., file 23-21535-FH. Mr. Bayonetto is now in the courtroom. You want to place your appearance on the record?
Yes, Alex Bayonetto for the people.
Ron Dunderwood for Mr. Olds this morning, Your Honor. Thank you.
Okay, and this is a final pretrial. We do have a trial date set for March 7th. Ms. Underwood, where do we stand with the case today?
We are prepared for trial, Your Honor. However, we have had discussions, and Mr. Olds is coming to my office tomorrow at 11 o'clock, and we are going to have some final discussions on this matter. And as I've told Mr. Bayonetto, if there is a resolution, we can obviously get it into court prior to any prior to the trial date, Your Honor.
All right, have proposed jury instructions and what other questions been submitted?
Ours should have been, yes, Your Honor.
We have read the prosecutors, and we would agree with those, Your Honor.
All right. Okay, are there any other issues that we need to resolve before trial then?
I don't believe so, Your Honor.
I don't believe so.
Okay, so trial date is March 7th at 9 a.m. If you should happen to reach resolution before then, please contact us as soon as possible. What we can.
Mr. Olds, I will see you in my office tomorrow at 11, okay?
Okay.
Thank you.
All right, thank you then, Mr. Olds. You're all set for today. Thank you.
Okay.
There's an officer there at the jail in Zoom 2. If we could get Bobby Brown next, that would be helpful.
All righty. Judge, is there anybody else that you're going to need?
We could take Barry Ellison if you have him available.
Okay, I'll see if they got an opening downstairs.
General, I think we also have Daniel Sloan who's in jail, and we're ready to proceed whenever we get him called.
Okay. You all set?
Mr. McGee, you want to come forward to the podium, please? Alexander McGee.
I don't know.
Is there an Alexander McGee here? Nobody in the hall. You're on there. Who's the person that's here?
Hey, Judge, just so you know, Ellison is downstairs, so I'm probably gonna have to wait till they open up before I can get him out for you.
Okay, that's fine.
Come in. There you go, mister. You weren't gonna sneak up on me, have a seat.
All right, Mr. Dagger Margosian, do you need a breakout session with Mr. Sloan? I think we've lost Mr. Dagger Margosian. Mr. Glazier, Mr. Lash is here. Do you need a breakout session with him?
Yes, I do.
Okay, Mr. Lash, I'm gonna place you in a breakout session with Mr. Glazier if you give me just a.
Okay.
Oh,
All right, the gentleman in jail Zoom 3, can you tell me your name?
Bobby Brown.
Ms. Underwood, you need a breakout session with Mr. Brown?
I spoke to him yesterday, Your Honor.
Okay. This is file 24-21735-FH People versus Bobby Jean Brown III. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
E. McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. Brown, Your Honor.
Yeah.
All right, and sir, you are Bobby Jean Brown III?
Yes, sir. I am. Yes.
Ms. Underwood, does Mr. Brown wish to have the information read?
We would waive the reading of the information, Your Honor, acknowledge its receipt and the receipt of the witness list. Your Honor, we would ask the court to enter a not guilty plea on Mr. Brown's behalf. Mr. Brown has a number of files, Your Honor, already up here. I have requested from the prosecutor's office that perhaps they could come up with an offer on a global resolution to these matters, and hopefully that can be done. So we would ask for a pretrial, probably in pretty short order, Your Honor.
All right, well, his other files we've got set for May 1st with a trial date of May 7th. So I think what I'm going to do is set a pretrial for May 1st, which is his final pretrial date with the other files. And if you do reach a resolution, again, you're always welcome to get on the docket ahead of that.
That's fine. Mr. Brown, know that is probably, we are, hopefully
Yes.
we will get something to you very soon, okay? That we can discuss. All
I got
right?
a question. Yes, I got a question. I do have, while I've been incarcerated for these months, I do have certificates that I've done within these months that I've been here.
That's great, Mr. Brown. And
I have done nothing but be progressive since I've been locked up. And also I do have certificates showing that I have done nothing but try to be on a steady pace of trying to improve myself while I've been in here. I did lose.
and I'm sure when Mr. Brown, I'm sure when I talk to the prosecutors, this will be something that we talk about, okay?
Okay.
But as soon as I can get that together, I'll be able to talk to you. All right?
Okay.
Thank you.
All right, so we'll enter a not guilty plea and set it for a pretrial on May 1st, again, with the understanding that if a resolution is reached, you can contact the office and get on the docket within probably a matter of a couple days.
Thank you, Your Honor.
All right, Mr. Brown, you can let the officer that's with you know that you're done with court for today.
Yes, sir. Yes, sir. I'm done. I'm done.
Okay, Mr. Murillo, do you want to come forward to the podium? All right, we are on the record in file 22-21008-FH, people versus Jesse Michael Murillo. We are here today for a request and summons for probation violation. We are proceeding today in person. Sir, you are Jesse Michael Murillo?
Yes.
Mr. Murillo, have you received a copy of the request and summons for probation violation?
No, Your Honor. I actually called they transferred me out to Washington, but she told me about it when I called her last Wednesday.
You didn't get a copy in the mail?
No, I did not.
Give me a second and we'll get you a copy.
I live out in Washington County, so it probably will show up in the next 2 or 3 days.
I'll need him to verify his address on the record.
All right, just hang on because we're on YouTube and I don't want that to be broadcast to the whole world. Take whatever time you need. Did the bailiff hand you that summons?
I
Okay, take whatever time you need to look that up.
do see
I don't want you to say anything about it yet. I need to ask you some questions so that you understand what your rights are before you decide whether or not you want to say anything, okay? The summons for probation violation alleges that you violated the terms of your probation by going to California on January 28th, by consuming alcohol on January 23rd and January 28th, by testing positive for alcohol on January 23rd, by using marijuana on January 23rd, 2024, and by failing to complete 480 hours of community service work. You had originally pled guilty in this case to operating motor vehicle with high blood alcohol content. Maximum penalty for that offense is up to 5 years in prison. You do have the right to be represented by an attorney at this hearing and at any other hearings that we might have on this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
I understand.
Do you want to be represented by an attorney?
Not as of right this second, no.
All right.
You can proceed.
Do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
You understand that throughout the trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence.
Yes.
You have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes.
You are not required to testify, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you'll have the right to testify if you wanted to testify. Do you understand that as well?
Yes.
Do you know how you'd like to plead with respect to violation of probation charges?
On the two of them, the going to California and the consuming alcohol.
Your ass going to jail today.
Okay. All right, Mr. Who is the person that's just talking now? What's your name? With the red coat or jacket? The guy in the red jacket with the hat on, what's your name, sir?
Oh, I'm sorry. I didn't know you could hear me. Sorry.
What is your name?
Cody Felton.
All right, Mr. Felton, I'm going to put you back in the waiting room.
Okay.
I apologize, Mr. Murillo. What?
No, but the consuming alcohol on the 23rd and 28th and going to California, those I knew about those, and me and my therapist and probation officer have.
Okay, I just need to know at this point how you want to plead, because I don't want you to say anything else, because I'm not sure where this is going to go, and I just want to know how you want to plead with respect to each charge.
Okay, the 469, that number is not correct. I have about 70 hours.
Okay,
done.
sir, I don't want an explanation again, because we might end up having a trial, and I don't want you to say anything right now that would be harmful to a position you might take.
Okay.
I just want to know, go down 1, 2, 3, 4, and tell me whether you want to plead guilty or not guilty to each one of those, please.
Okay, yeah, guilty on 1, guilty on 2, guilty on 3, not guilty on 4.
All right, Ms. Holly, do you want to resolve it by him pleading guilty to the first 3 and not to the 4, or do you want me to set this for a hearing?
No, we can resolve it. I'll just address the community service in the report.
All right, so Mr. Morello, would you raise your right hand?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You heard me describe all of the rights that you would have if we moved forward with a not guilty plea. Is that correct?
Yes.
And do you understand all of those rights?
Yes.
You understand that you're waiving those rights by pleading guilty?
Yes.
Do you understand that means includes that you're waiving your right to a trial and your right to have your lawyer's assistance at that trial, as I've explained?
Yes.
Has anything been promised to you in order to get you to plead guilty today?
No.
You've been threatened in any way in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
You were placed on probation in this case back in about December of 2022. Is that correct?
Yes.
And the court file contains an order of probation that I signed, and there's a defendant signature line with a signature on that. Did you receive and sign the order of probation?
Yes, I remember that.
One of the terms of your probation was that you not consume alcohol. Is that correct?
Yes.
And did you consume alcohol on January 23rd, 2024?
Yes.
Did you also consume alcohol on January 28th, 2024?
Yes.
Another term of your probation was that you not leave the state without permission of the court or your probation officer. Is that correct?
Yes.
And did you leave the state of Michigan on January 28, 2024 and go to California?
Yes. And if there's a, I don't know if I don't want to interrupt, but can I, in my watching out probation officer, there was I tried to do that by the book on the going to California. She had not changed her voicemail and I heard that she was on vacation. So I kind of stopped listening, but she didn't change her voicemail from when she got back. So instead of telling my probation officer, I did tell my therapist, I tried to do this right before, not telling anybody.
Okay, but at the end of the day, you
I
didn't
did not
get your
know.
probation officer's permission. Is that right?
Yes.
Okay. And another of your conditions of probations was that you not use any controlled substances. Is that right?
Yes.
And did you use marijuana on January 23rd, 2024?
Yes.
All right. I will accept those pleas, then they have been given understandably, voluntarily, and accurately. Mr. Murillo has had full knowledge of his rights and he's had confidence.
Did he address the alcohol?
I'm sorry?
Did the alcohol condition get addressed?
Yes.
Oh, okay. He admitted to that?
Yes.
Okay.
All right, I'm going to
Okay.
set sentencing for March 14th at 8:15 a.m.
Is his address the same as on the paper?
Mr. Monroe, is your address the same as on that summons that I handed you?
Yes.
That's your current address?
Yes.
Okay.
Okay.
So I'm going to refer the matter to the probation office for an update of your pre-sentence investigation. We're going to set sentencing for, what was the date? I said March 14th. When you do your interview to update your pre-sentence investigation report, please be truthful about these offenses and about your background.
Will do.
Okay. All right. So we'll see you back for your sentencing.
On what day?
March 14th at 8:50.
March 14th. Thank you.
Thank you. All right, Mr. Blazer, are you ready to proceed with Mr. Lash?
Yes, I am, Your Honor.
Okay, let me pull him back in.
So you did it. Good.
Okay, we are on the record in file 23-21421-FH, People versus Chad Thomas Lash. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. I'm going to mute Mr. Lash's device because it's causing some audio feedback that's making it difficult for us to hear in the courtroom. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bandetto?
Alex Bandetto for the people.
John Glazier on behalf of Mr. Lash, Your Honor.
Okay, so we have there it is. We have a trial date scheduled for March 8th. Where do we stand with the case today?
I didn't realize we had a trial date set that quick, Your Honor. My client is what was in we sent paperwork over. He's been admitted over at Monroe, the psych ward, on 2 or 3 occasions since we were here last. The last court hearing I had showed a bench warrant, but evidently he was over in Monroe in the psych ward. He's now in an inpatient program. Mr. Bandetto has offered him a plea to a possession and drop everything else. I think we want to do that, but I need a little bit longer to talk to Mr. Lash. What is March 8th? Is that when is that?
It's next Friday.
Next Friday.
Is there any way we could maybe put this on a like Monday or Tuesday where we could also talk with Your Honor? He's in a program right now. He's where are you at, Mr. Lash? I know there's a worker there with him.
I'm sorry, I had muted his device because it was causing some feedback. So let me send a request to unmute it.
The Hope House in Jonesville?
The Hope House in Jonesville? Okay.
Yeah.
I think we would be ready to enter a plea Monday. I just need to talk with Mr. Lash. You know, Your Honor, why don't I talk to him right now? A little bit. I have
There's also the pending motion to suppress that defense had filed. I understand they did withdraw the motion as it related to the search, but there is still a motion pending for a I believe it was a potential Miranda violation.
Right.
That still needs to be addressed. At the last pretrial we had, the court had issued a bench warrant because Mr. Lash had violated his bond conditions, and I believe the statement made to Mr. Coast was, "You're gonna have to come get me because I'm not gonna come in and test anymore," or something to that effect. That's why the bench warrant has been pending for the last month. Because Mr. Lash never turned himself in, we were never made aware of this. Given the motion that's outstanding as well, if we can't reach a resolution on Monday, I have multiple jury trials that are set for next week. I don't know that we'd be able to get that motion heard prior to next Friday's trial date.
I think you're misunderstanding. I think once I talk to my client, we will enter a plea and that'll take care of the motion and everything. In fact, if you want to give me a little bit of time this morning, Your Honor, I can talk with him at more length today and maybe we can take care of it right this morning. That might be easier than putting this off till Monday.
Yeah, I can do that if that's what you prefer. Whatever way you want, Mr. Glazier.
Let me have a little bit of time to talk to Mr. Lash, and I'll try to get back on in about 5 or 10 minutes. I don't know how long it's going to take.
Okay, you want to do that separately, or do you want me to put you in a breakout room?
If you could put me in a breakout room, because he's over in Jonesville.
Okay, yeah, I will. Let me get that done right now.
Okay.
All right, the gentleman in jail, Zoom 3, you are Mr. Dahan?
Yes, Your Honor.
Okay, Ms. Underwood, do you need a breakout session with Mr. Dahan?
Just briefly, Your Honor. Thank you.
Okay. And Mr. Dagger Margosian, you've got Mr. Sloan here. Do you need a breakout session with him?
No, Your Honor, we're ready to proceed.
All right, give me a moment. We're on the record in file 24-21689-FH, 24-21690-FH, and 24-21691-FH. People versus Daniel Robert Sloan. We are here today for a pretrial conference in these cases, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bannon.
Alex Bayoneto for the people.
Your Honor, Michael Dagger Margosian for Mr. Sloan.
All right, and Mr. Dagger Margosian, where do we stand with Mr. Sloan's cases today?
Your Honor, there is a plea agreement that I can place on record, and Mr. Sloan will be entering pleas to it.
Okay, and if you want to go ahead with that agreement, then I'll ask Mr. Bayoneto to confirm.
So in case ending in 9-0 FH, Mr. Sloan will be pleading guilty to count 1, possession of meth. In case ending in 8-9 FH, he'll be pleading guilty to count 2. And pursuant to that, he's also been screened for drug court, and part of it is entry into drug court. And upon a plea of count 1 on 90 FH and count 2 on 89 FH, the remainder of the charges, including all of 91 FH, will be dismissed. There's also a misdemeanor case not in front of Your Honor, but that case will also be dismissed.
Okay, Mr. Bayoneto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right, Mr. Sloan, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Daniel Robert Sloan?
Yes, Your Honor.
Mr. Sloan, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention in file 24-21689-FH to plead guilty to count 2, possession of a Schedule 5 controlled substance?
Yes, Your Honor.
Is it also, or I'm sorry, do you understand the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine?
Yes, Your Honor.
In file 24-21690-FH, is it your intention to plead guilty to count 1, possession of methamphetamine or ecstasy?
Yes, Your Honor.
And do you understand the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes, Your Honor.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as has been discussed on the record this morning. Is that correct, Mr. Bayoneto?
That's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Sloan?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Sloan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead in charge 24-21689-FH to the charge that on or about July 10, 2023 in the city of Adrian, County of Lenawee, you did commit the offense of possession of a Schedule 5 controlled substance?
Guilty.
And how do you wish to plead to the charge in file 24-21690-FH that on or about October 21st, 2023 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of possession of methamphetamine?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand if I accept your pleas, you're giving up any claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Sloan to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Sloan, other than as we've talked about on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, Mr. Dagger-Margosian, do you want to establish the factual basis?
Sure, Your Honor. Mr. Sloan, on July 10th of 2023, were you in City of Adrian, County of Lenawee, State of Michigan?
Yes.
And on that date, did you possess controlled Schedule 5 controlled substance, maybe more commonly known as mushrooms or shrooms?
Yes.
All right. And did you didn't have a legal right to possess?
No.
Okay. And you knew that you had it on you?
Yes.
Okay. I think I'm satisfied with that case.
Satisfied with that case?
I'm satisfied, Your Honor.
All right, thank you.
And then additionally, Mr. Sloan, on October 21st of last year, again, were you in Adrian Township, County of Lenawee, State of Michigan?
Yes.
And on that date, did you have methamphetamine on you?
Yes.
And you knew that you had it on you?
Yes.
And you didn't have a legal right, you did not have a legal right to possess that?
No.
Okay. And you have no reason to dispute that it was in fact methamphetamine?
No.
Okay. Satisfied with that, Your Honor?
Satisfied, Your Honor.
Right. Has the court complied with MCR 6.302 B, C, and D, Mr. Van?
It has, Your Honor.
Mr. Dagger-Margosian?
Yes, Your Honor.
I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Sloan has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement in this case regarding the possibility of a plea or possible sentence with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we discussed on the record here this morning. I will refer this matter to probation department for a pre-sentence investigation and set sentencing for April 5th at 8:15 a.m. Mr. Sloan, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yeah, Your Honor.
April 5th. All right, Mr. Sloan, you are all set for today. Then you can let the officer that's with you know that you are done with court.
Your Honor, if I could just address one thing, if I could ask the prosecutor to file a nollie pros on 231460 OM. We have again, it's not in front of your Honor, but there's a pretrial date in district court, and because that case is being dismissed, I'd like to just cancel that court date. So I just ask the people to file the nollie pros on that.
That's fine. I'll do that. That's fine, please.
Okay.
Nothing further. Thank you, Honor.
All right, we're all set then. Thank you.
Thank you.
Okay, Mr. Dagger-Markosian, I've got Mr. Felton here. Are you going to need a breakout session with him?
Yes, please, Your Honor.
Okay. All right, Mr. Felton, I'm going to place you in a breakout session with Mr. Dagger-Markosian, if you give me just a moment.
Yes, sir.
Okay, Mr. Glazier, Mr. Lash, I apologize. I clicked the wrong button and pushed your breakout room. All right, and Ms. Underwood, are you ready to proceed with Mr. DeHaan?
Yes, Your Honor. Thank you.
Okay, 1 second. Okay, this is file 23-21218-FH People versus Adam Daniel DeHaan. We are here today for a hearing on a probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. DeHaan this morning. Thank you, Your Honor.
Okay, and where do we stand with Mr. DeHaan's case today?
Mr. DeHaan wishes to accept responsibility and plead guilty to the violation today, Your Honor.
All right, Mr. DeHaan, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Adam Daniel DeHaan?
That's correct.
Mr. DeHaan, do you understand that you have a right to contest the violation of probation charge and have a trial on it?
Yes.
Do you understand you also have a right to contest the contempt of court for failure to appear and have a trial on that?
Yes.
Do you understand that throughout that trial with respect to the probation violation charge, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, Your Honor.
Do you understand with respect to the contempt charge, you again have a right to a trial and can't be convicted unless the evidence proves that you're guilty beyond a reasonable doubt?
Yes, Your Honor.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have you order any witnesses they have for your defense to appear at your trial. Do you understand all of that?
Yes, Your Honor.
You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well?
I do.
How do you plead to the charge that you failed to appear in court for a violation of probation summons?
Yes. I think.
So if you want to plead guilty, you need to say guilty.
Guilty.
How do you plead to the charge that violated the terms of your probation by failing to report to your probation officer after being discharged from Hope House?
Guilty.
And how do you plead to the charge that you violated your probation by not completing your treatment at Hope House?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes, it is, Your Honor.
All right. You were placed on probation in this case back in May of 2023. Is that right?
Yeah, it should be.
And one of the terms of your probation was that you enter into and complete any substance abuse treatment that you were referred to by a field agent. Is that right?
That's correct.
Okay. And were you referred and did you go to Hope House at some point?
Yes, I actually went.
Okay. And did you get discharged or did you leave that program without completing it?
Yes.
Okay. And after you got discharged or left the program, did you fail to report to your probation officer?
Yes, Your Honor.
Did you report at any time between the time you left Hope House and the time you got picked up on the warrant?
No, Your Honor.
All right. I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. DeHaan has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation office for an update of your pre-sentence investigation and set sentencing for March 14th at 8:15 a.m.
Did you say March 4th, Your Honor?
14th.
14th? Thank you.
Okay, so Mr. DeHaan, when you do your updated pre-sentence investigation interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
Okay, you're all set. You can let the officer with you know that you're done with court for today.
Thank you. Yeah.
All right, Ms. Underwood, do you need a breakout session with Mr. Madrid?
Your Honor, I believe Mr. Malero is going to handle Mr. Madrid.
Oh, all right. Mr. Woltius is here. Do you need a breakout session with him?
No, I do not, Your Honor. And I would apologize. We meant to file a waiver on Mr. Woltice. So that's why we're a little he's a little late this morning. He very
I don't
kind.
have him on our docket. Do you have that, case number?
Oh, you don't have him on your docket?
I do not.
Maybe,
You know his case number?
yeah, maybe there was a waiver filed. Maybe it's just not. Hang on. Two. Let's see. 2421734 FH.
That's a Judge Anzalone.
What?
Yeah, that's Angelo's case.
That's an Angelo case? Oh,
Yeah.
no. Okay. Thank you.
Who are you calling?
All right, Mr. Woltius, are you there? Mr. Woltius, if you're there, I'm gonna need you to unmute your device, please.
I'm sorry
All
about that, Honor. Am I coming through now?
Okay.
Yeah, you're good. So I'm gonna send you in the chat the Zoom ID for Judge Anzalone. So write that down, log out of this courtroom, and then log into hers.
All right. I'm writing it down as we speak.
Okay.
Could I have it up again, please? I just got two numbers.
It's 993
993
558
558
3219.
3219. Okay, thank you.
All right, thank you.
Mr. Waldheis, I'll be over in a couple minutes.
Okay.
Thank you.
Okay.
All right, this is file 22-20750-FH People versus Mason Bradley Lindeman. We are here today for arraignment on a bench warrant. We are proceeding today by video conference. Sir, you are Mason Bradley Lindeman?
Yes, I am.
Mr. Lindeman, have you received a copy of the warrant?
Nope.
Serious for a minute.
Give me just a moment, Mr. Lindeman, I'm gonna be able to put it up on the screen if you give me just a second. All right, Mr. Lindeman, that is a copy of your warrant. There is more if you scroll down to the bottom, so let me know when you've had a chance to read the top portion, and I'll scroll down for you.
I can't read, so that ain't gonna do no good.
I'll open the door and be down there.
All right, the warrant alleges that you failed to do a drug screen on August 21st of 2023 with Mr. Coast as you had been directed, and that you failed to provide the court with a valid mailing address. The maximum possible penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the right to be represented by an attorney at this hearing and any other hearings that we have on this matter. If you can't afford an attorney, you can tell me that. I'll point one for you at public expense. Do you understand that?
Yes, I fired my last lawyer, so I would actually need one.
Okay. Do you have the ability to pay for your own attorney?
I don't have the fundings right now. I paid for the last one. I didn't receive my money back.
All right, Ms. Yeah, I'm sorry.
No, the court has already, he's already been through the public defender's office as well. I believe we would need a special appointed public defender on if he wants an attorney on this bench warrant, but also on the underlying case.
Okay. Mr. Lindeman, do you know how long you're going to be? You're in Jackson right now?
I got, I think, just a little over a month, and I'm maxed out on my time.
So you have about a month left to serve?
Yes.
Okay. What I'm going to do is appoint the public defender's office to represent you. They're going to have to, sounds like, appoint a special public defender outside of their office. So I'll enter a not guilty plea on the contempt right now, and I am going to set the underlying case as well as the contempt for a pretrial on March 13th. So that should still be while you are in Jackson.
Yes.
And which facility are you at in Jackson?
Tanner Road.
Canner Road. Okay. So we will make arrangements with them to have you available on March 13th.
You got this remote?
Your Honor, could I ask what his bond is set on the underlying?
The ISO.
So the bond was revoked when the bench warrant was issued. Whatever bond you had was revoked at that time, and the bond on the bench warrant is $50,000.
Thank you.
All right, so Mr. Lindeman, you're all set with us for today. We'll see you back on March 13th when we have a special public defender for you.
Thank you.
Okay, thank you.
Throw that everywhere. Second time you dropped that bitch today?
Okay, Mr. Dagger-Margosian, you ready to proceed with Mr. Felton?
Yes, Your Honor.
Okay, this is file 23-21654-FH People versus Cody James Felton. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Your Honor, Michael Dagger-Margosian for Mr. Felton.
All right, and so where do we stand with Mr. Felton's case today, Mr. Dagger-Margosian?
Your Honor, Mr. Sneed and I have essentially worked this case out. We waived the preliminary exam to complete the plea in circuit court. We just need a little bit more time to complete things on our end of things. And so I would just be asking the court to adjourn this for another pretrial, maybe in the range of a month or 6 weeks, something there like that.
Okay, Ms. McClure, anything we need to address from the people's side?
Nothing, Your Honor, thank you.
Okay, how about April 10th at 8:15?
That should be fine, Your Honor.
Okay, Mr. Dagger-Margosian, would you be willing to do a stip in order for that adjournment?
I will.
Okay, so Mr. Felton, your next date then is April 10th at 8:15. You can log in with all the same Zoom information that you used today.
Yes, Your Honor.
You're all set then, you can log out.
Thank you.
Thank you, Your Honor.
This recorded. All right, Ms. Underwood. Sorry, it looks like Ms. Underwood has logged out for a moment. Mr. Inkland, do you want to come forward to the podium, please? We are on record in file 23-2252-SM. People versus Vincent Matthew Inkland. We are here today for a trial conference in this case. And we are proceeding today in person. First, let me have Mr. Bayanetto place his appearance on the record.
Alex Bayanetto for the people.
All right, and sir, you are Vincent Matthew Inkland?
Yes, Your Honor.
All right, and we are in a circuit courtroom today, but this is a district court felony case. I'm sitting by assignment due to the disqualification of other judges. So, Mr. Bayanetto, it appears I have a plea agreement in the file. Is there an agreement for a plea in this case?
There is, Your Honor. The plea agreement should reflect that Mr. Inkland will be entering a plea to a domestic violence first offense rather than the second offense. We were ready to take that plea when Judge Morgan realized that there was a conflict, which is why it got assigned to you. I did speak with Mr. Inkland this morning, and he did indicate he still wished to go forward with that plea.
All right, Mr. Inkland, do you still wish to go forward with that plea?
Yes, Your Honor.
All right, would you raise your hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Vincent Matthew Inkland?
Yes, sir.
You've heard the statement of the prosecuting attorney. Is it your intention to plead guilty today to domestic violence first offense?
Yes, Your Honor.
You understand the maximum possible penalty for that offense is up to 93 days in jail?
Yes, Your Honor.
You are not represented by an attorney currently. Do you understand you have a right to be represented by an attorney?
Yes, Your Honor.
Do you understand that if you don't have the money to pay for an attorney, you can tell me that and I'll appoint one for you at public expense?
Yes, Your Honor. I understand.
Do you still want to proceed without having an attorney?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf to discuss a possible sentence with the court. Is that correct, Mr. Bayanetto?
That's correct, Your Honor.
Is that also your understanding, Mr. Inkland?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up all the rights that you would have had at trial, and explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have me order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you're convicted of a trial?
Yes, sir.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand all those rights that I've explained to you?
Yes, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about June 3rd, 2023 in the village of Morenci, Lenawee County, Michigan, that you did commit the offense of domestic violence first?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
You understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea.
Yes, Your Honor.
Is the prosecutor aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Inkland to plead guilty?
No, Your Honor.
Mr. Inkland, has anybody promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
On June 3rd, 2023, were you somewhere within Morenci, Illinois County, Michigan?
Yes, Your Honor.
And were you in contact with the alleged victim in this case, whose initials are RC?
Yes, Your Honor.
And did you in some way assault her, or what happened that led you to get charged with this?
I did assault her, Your Honor.
Okay, how did you do that?
By putting my hand out forward and moving her head to the side, which her head caused her head to hit the side of my truck.
Okay, so you pushed her head and her head hit the truck.
Yes.
Okay. Mr. Bano, are the people satisfied with the factual basis?
Mr. Inkland, the alleged victim in this case is Rosa Cordova, correct? Yes, Your Honor. And you two share children together? Yes, we do, Your Honor. I'm satisfied now, Your Honor.
Okay. All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Bano?
I believe it is, Your Honor.
Okay. I will accept the plea that has been given understandably, voluntarily, and accurately. Mr. Inkland has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding possibility of a plea or possible sentence in this case with the prosecutor or the defendant or anyone acting in the interest of any of them. I will refer this matter to the probation department, so that'll be district court probation on the first floor. You'll need to report there, I believe, on Tuesday at 8 a.m. Is that what they usually do, Mr. Mick?
That I'm not sure, Your Honor. I think maybe he checks in today.
So why don't you go downstairs to the first floor of the probation department and ask them when you need to show up there for a pre-sentence investigation interview or set sentencing for April 11th at 8:15 a.m.
I think Thursday's the day he takes them in. District
Okay.
court.
All right, well, just stop down on the first floor and they'll let you know for sure. Okay, anything else we need to address in the matter today, Mr. Bennett?
No, Your Honor.
Anything else for you today, Mr.
Your Honor, for the record, since this has happened, there has been a crisis in her household where the kids are now with me. She has been evicted from her place. So my children, all of them are with me. I just wanted to state that for the record.
All right. That's something you can discuss with the probation officer. There's going to be a report about what's going on, and that report will get to
This is all recorded.
Yeah. All right. Okay. Thank you. You're all set for today.
Thank you. Thank you, Your Honor.
Okay, Mr. Glazer, are you ready to proceed with Mr. Lash?
Yes, I am, Your Honor.
All right, let me pull him back over from the breakout session. Okay, we have Mr. Lash and Mr. Glazer back from the breakout session. Is McClure, are you there?
This is my case.
Oh, I'm sorry, this was your case. I apologize. Never mind, Ms. McClure, false alarm. So we are back on the record in file 23-21421-FH, People versus Chad Thomas Lash. Mr. Glazer's had an opportunity to speak to Mr. Lash in a breakout session. Mr. Glazer, do you know how Mr. Lash wishes to proceed today?
Yes, Your Honor. he is going to enter a plea of guilty to count 1, the possession of methamphetamine, with the understanding that counts 2, 3, and 4 would be dismissed at the time of sentencing. I've had a discussion with the assistant prosecutor. I've advised him that I was going to ask the court to consider giving him section 7411 at the time of sentencing, or if not at that time, maybe at the end of his probation, see how he does with his probation. I know in talking with the assistant prosecutor, he was going to object to that. He had offered the same plea with 7411 a ways back, and I can't tell you how far back, but that was being handled by Miss Van Duzen, and at one point it was being handled by Mr. Margosian before that. And he says because they kept getting turned down, that he was not going to recommend it at this time. I would just indicate, I want to indicate for your honor that Mr. Lash had been told by our office that this matter was going to be dismissed, that there was no way that he was going to get convicted of this. And there's a motion filed, which I've indicated to the court, we don't even have standing to file the motion for the illegal search. But so Mr. Lash said, why would I have taken a plea with a 7411 when my attorneys are telling me that it's going to be dismissed? And that was the whole reason this didn't get resolved way back when. It should have got resolved with a plea and a 7411. And Mr. Bay, that we're going to enter the plea, and I guess the 7411 is either going to be up to you at sentencing or at a later point. And Mr. Bayonetto, I know, will object to it at sentencing. But I just wanted to put that portion on the record. And when we take the plea, we'll indicate to you how Mr. Lash wants you to know how little methamphetamine there was. In fact, he thought it was cocaine.
Your Honor, if I may just clarify that, it wasn't just because the defendant didn't accept it. There were multiple bond violations. There were multiple instances where the case was set for preliminary examination. At one point, Mr. Lash came into the courthouse, just walked out after the officer was already subpoenaed. We were ready to go for preliminary examination. That was why the plea offer was withdrawn at that time. So it wasn't just that because Mr. Lash didn't accept it in a timely fashion, we withdrew it. There was quite a bit of intervening circumstances when that offer was withdrawn. So I just did want to clarify that for the record.
Okay, so what I understand is that there is an agreement to plead to count 1.
Yeah.
But there's no agreement with respect to the sentencing at this point. And
other than no upfront jail, Your Honor, there is an agreement.
Right.
That is correct, Your Honor. Given that Mr. Lash is currently in treatment, I will agree to no upfront jail.
Okay, so there's an agreement to plead to count 1 with no upfront jail. The parties disagree on the 7411 issue, and we'll resolve that issue at the time of sentencing when I have a PSI and some more information about Mr. Lash's situation. So
absolutely, and I don't disagree with what Mr. Bayonetto said just now, Your Honor. I don't know. Somebody else in our office was handling it, and I can't confirm one way or the other what happened before this.
All right. So, Mr. Lash, I'm going to send you a request to unmute that device so that we can hear you.
Okay. Can you hear me?
Yes. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Chad Thomas Lash?
Yes, Your Honor.
Mr. Lash, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of methamphetamine or ecstasy?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that he's given you?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that, other than as we've discussed on the record here, is that correct, Mr. Bennett?
It is, Your
Honor. Mr. Glazer?
That's correct, Your Honor.
Is that also your understanding, Mr. Lash?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial with a jury. You could ask for a non-jury trial, and if the prosecutor and court agree, you have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. However, you also have the right, you have the right to have the prosecuting attorney prove beyond reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Lash, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that if you appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States, or denial of naturalization. Do you have any questions about those rights?
No, Your Honor.
Mr. Lash, are you taking any medications or anything right now that would interfere in any way with your ability to understand those rights and make decisions about them?
No, Your Honor.
All right. How do you wish to plead to the charge that on or about February 11, 2023, the city of Adrian, county of Lenawee, that you did commit the offense of possession of methamphetamine?
Yes, Your Honor.
If you want to plead guilty, you would need to say guilty.
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Prosecutor or defense counsel were promises, threats, or inducements of the plea bargain to induce Mr. Lash to plead?
No, Your Honor.
No, Your Honor.
Mr. Lash, other than as we've talked about on the record this morning, has Mr. Glazer promised you a particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Glazer, do you want to cover the factual basis?
I will, Your Honor. Mr. Lash, on February 11th of 2023, you were here in Lenawee County and in the state of Michigan. Is that correct?
Yes.
And at that time, you were a passenger in a motor vehicle. Is that correct?
Yes.
And you got pulled over by, I believe it was the state police. Is that true?
Yep.
And after you were pulled over, you were subsequently arrested, I believe. Is that correct?
Yeah, we were searched and then the car was searched.
Okay, and you were eventually arrested. But when you were searched, in your possession, in your wallet, there was a baggie with a small amount of what turned out to be methamphetamine. Is that correct?
0.01 grams.
I'm going to go over that. I'm looking at a lab report that says 0.01 grams was a little more than residue probably in that bag. Is that correct?
Basically residue, yes.
Okay, and I have a lab report that says it's methamphetamine. You thought it was cocaine, is that right?
That would be correct.
So you were possessing illegally. You just thought it was cocaine and it ended up being meth. Is that true?
That's correct.
All right, and I want to cover a couple other things that we discussed today and put these on the record. I've explained to you that this is set for trial on March the 8th. You understand that?
Yes.
And if you went to trial if you would have got convicted of the felony firearm, that you have to go to prison on that. You understood that.
Yes.
And so even though you think maybe the plea bargain offered you was a little unfair, you understand that you really have, I mean, if you went to trial and lose, you're going to lose big. You're going to go to prison. You understood that.
Yes.
All right. Also, as regards to the 7411, I wanted to again clear that up. You were not represented by me, but somebody else in our office. Is that correct?
Yes. And the judge changed my bond conditions during that time because I was on random drug screening, and then she just randomly out of the blue took me off a random drug screening and put me on the tether.
Okay.
So when she did that, it changed my whole bond condition from drugs to alcohol, which I don't know how she did that.
All right. Well, the judges can do more than you think. But I just want to indicate, you understand that at one point you were offered this plea with a 7411, and you turned it down because you were being told the case was just going to get dismissed.
Yeah, they told me that the case was going to get dismissed. I just had to take care of the violation.
And I've explained to you it's not going to get dismissed because you don't even have standing under that motion as a passenger to vehicle. You understand that?
That'd be correct.
Do you understand that?
Yes.
All right. So that's why you're taking this plea, and that's why you turned it down to begin with. And
Yes.
And I did explain to you that we're going to ask the judge to give you 7411 over the prosecutor's objection at sentencing. And it'll be up to him whether he gives it to you at sentencing, or he could even give it to you at the end of your probation. But that's up to the judge, and the prosecutor's going to object to it, and you understand that.
Yes, I understand.
Okay. I don't have any other questions, Your Honor.
All right, Mr. Bagnetto, are people satisfied with the factual basis?
There's just one question I'd like to ask Mr. Lash. Mr. Lash, your attorney indicated you thought it was cocaine that was in your wallet. Do you have any reason to dispute that it was methamphetamine?
I didn't know there was a baggie in my wallet at the time. But so I can only assume what the test shows.
Okay, so you're not disputing that it was found to be methamphetamine that was in your wallet.
That's what the test shows. I guess that's what it has to
be. Your Honor, I have the lab. I didn't have it till today, but it's been sent to me, and it shows what was tested. It shows the suspect is Chad Lash, the date that it was sent, and that it was 0.0100 grams of methamphetamine.
I'm satisfied.
Has the court complied with MCR 6.302B, C, and D, Mr. Bagnetto?
Yes, sir.
Mr. Later?
Yes, it has, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Lash has had full knowledge of his rights, and he has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation, and will set sentencing for April 11th at 8:15 a.m.
Okay. And how does Mr. Lash get a hold of the probation department? He's in that program over at Jonesville. Is that something?
Is he able to leave the program?
I'm in inpatient treatment at the Hope House.
I guess I need an address and phone number.
Okay, the phone number is 517-849-2330. I'm not exactly sure what the address is though.
Is your address listed on the police report?
My home address is listed on the police report.
Do you have a cell phone?
We're not allowed to have our cell phones in here.
So are you on probation with someone else?
No. No, I'm not on probation, nothing like that.
Mr. Lash, how much longer are you going to be at Hope House?
Well, the program is 30, 60, 45, or 90 days. So it depends on when I graduate.
How long?
I've been here for 1 week. I came straight from the psychiatric unit in Monroe to here a week ago today. So I have so I have 7 days in so far.
I guess we'll have to call Jonesville.
Okay, Mr. Lash, if you are released before the sentencing date, I want you to contact the probation department here in Lenawee County the same day that you're released, okay?
The same day I'm released from here.
Yeah.
Okay. All right. Thank you, Your Honor.
And you understand if you're still in there, we got to get back on Zoom on April 11th.
Yes.
Okay.
So Mr. Glazier, what did Mr. Lash want to do with the violation of bond conditions?
Can we address that at the time of sentencing?
Okay, so I'll set that for hearing on the sentencing date of April 11th.
Right, and I don't know, I don't think the court has any bench warrants out. But I would ask, you know, he's over at Hope House, and if there is, it could be recalled. The last note I had on the 24th said a bench warrant was issued, but I think he sent you documentation of his hospitalization since that time. Both at Prolong and now at Hope House.
All right, so the warrant that we have outstanding is for a failure of drug screen on 11/9, or I'm sorry, 11/19, so November 19th of 2020. That is not a date that is covered by the letter and the email I have about his.
Yeah, I'm not aware of that one. The only one I had was a bench warrant on the 24th, January 24th. I'm not sure of the 11/19 what that one is.
Yeah, I think procedurally what happened was he tested, or the bond violation happened. Mr. Glazier took over the case. We set it out for a hearing. Then at that point, when Mr. Lash did not turn himself in, the court issued the bench warrant for the failure to appear. So that would have been outstanding prior to our bench conference that we had. Jury.
Yeah, I'm not, Your Honor, there's been a lot that's gone on in this case, and I can't tell. All I can tell you is I know he's in Jonesville. There's a worker there with him, and I guess I'd ask the court to consider withdrawing it, but if you don't want to, that's fine too. If they want to go arrest him and take him from Hope House, I don't think that's
I know everything all right out here.
Okay, so on the 24th, we had a hearing, didn't appear. I said that I would wait 48 hours before issuing a bench warrant, and it doesn't appear, according to the register of actions, that a bench warrant ever got actually issued on that date.
Okay.
So there's no that I can see with respect to in January. There is still a bench warrant for the failure to test from November. What I will do with that, given the circumstances, Mr. Lash is in treatment at the moment. I'm going to enter a not guilty plea on the contempt for failure to test. I'll issue a PR bond on that so that he can remain at Hope House and continue receiving his treatment, and can address that again on the sentencing date of April 11th.
Okay. That should take care of everything as far as I can see.
I think so, and I hope so.
These things get a little complicated sometimes. All right.
Yeah.
Your Honor, I got one other thing with you, but I gotta run in a quick short appointment. Can I come back in about 20 minutes?
Okay, all right, so yeah, Mr. Lash, you can go ahead and log out, and Mr. Glazer, I'll see you.
Okay. All right, thank you, Your Honor.
Your Honor, we had Miss Hennigan log in to address something that's not on your docket. And I think
Yeah.
Miss Clark gave you that file. I
Yeah,
think we
yeah,
only have Miss Hennigan for a short window, so if the court would hear us out.
Is there anything you need to do on the record with this case?
I don't think so, but once we talk to you, I guess we can see.
Okay. Ms. Hennigan, are you there?
I am here, Your Honor.
Okay, so this was about Ms. Frank's case, and I guess my understanding you need to reschedule the trial.
Yeah, and I wasn't sure if there was going to be an objection by either the court or Miss Hennigan, so I did want to address it here with all of us. Just that I understand it's set for 2 days. I think it's beginning March 12th. Yes, March 12th and 13th. And I have another trial in Judge Anslone on the 13th that had the final pretrial today and I believe is going. And it is an older case and she's in custody. In addition, I have maybe 15 witnesses, I think was my count on this case. And we're only set for 2 days. I think this is more than likely a 4-day jury trial, unless I can get with Miss Hennigan and get some stuff stipulated too. So I guess I would ask, taking that into consideration, if the court would give us a new trial date that's 4 days long and pushes it out a little bit. I don't think Miss Frank is in custody. Is that right, Miss Hennigan?
It's not. And I don't have any objections to rescheduling this, Your Honor.
All right, so 4 days.
Yeah, I think it's just going to be a little bit lengthier than we initially anticipated.
All right, Ms. Clark, we're gonna need a 4-day jury trial date.
Tuesday, April 16th, April 17th, April 18th, and April 19th.
I'm out of the country that entire week.
Did you want this as a backup to anything, Judge?
Ms. McClure, Ms. Hennigan, any thoughts on whether you want to be a backup to something or?
I guess it depends what it's a backup to. I think it'd be pretty tricky to make it a backup to the Simmons homicide, the Winsett Silvertooth case. You know,
This would be to Levi.
What date is that?
The 23rd, 24th, 25th, 26th.
Of April?
Yes.
I think I already have a different trial.
Yeah, that's Levi Scroggins.
Oh yeah, Levi Scroggins, right? I do have that one.
And I have Douglas Toms in front of Judge Anslone that week.
Okay. April 30th, it'll be a backup to Michael Pulsifer. May 1st, May 2nd, and May 3rd.
Phoebe, if it works for you, I'll do it, but you're gonna owe me drinks on the 2nd because that's my birthday.
I'm showing, do you have Chad Bordner already scheduled and Thomas Soto?
Yeah, so you're
You
right.
already have 2 set that week. One's with me and one's with Isaac.
June 4th, June 5th, June 6th, and June 7th. Those will be a backup to civil trials.
I look good for that week.
Also good for that week.
So June 4th through the 7th. Let's do a final pretrial on May 29th.
At what time, Your Honor?
Pretrial will be 8:15.
Thank you.
Thank you, and I appreciate the court hearing us out on this one. I know it's kind of a last minute, but I always try and bring conflicts as I know of them.
So I'll issue a new scheduling order. Is there anything that either of you want to place on record?
I don't think so.
No, I don't need to.
Are we vacating the date on the 6th, our final pretrial next week? Okay. Then no, I don't think so.
Okay. We will send you a new scheduling order.
Thank you very much, Your Honor.
Thank
Thanks,
you. Thank you,
Phoebe.
Tamaris.
No problem.
Ms. Underwood, you need a breakout session with Mr. Verlinde.
Your Honor, I don't believe I do. I have had discussions with the prosecutor. We were waiting for a determination on certain decisions the prosecutor is going to make about new charges possibly. Those have not been made yet. We would ask the court to consider a 1-week adjournment, Your Honor, in this matter. The prosecutor thinks they will be done with their assessment by then.
All right, let me call the case. So this is file 23-21206-FH and 23-21604-FH, People versus Kevin Ryan Verlinde. We are here today regarding a alleged probation violation. First, let me have the attorneys place their appearance on record, beginning with Ms. Wagner.
Good morning, Your Honor. Amanda Wagner for the people.
Rhonda Underwood for Mr. Verlinde this morning.
All right, and Ms. Underwood, you had indicated off the record that you're still waiting to find out whether there are going to be new charges related to what's alleged in the probation violations, and you'd like to adjourn this for a week. Is that accurate?
I believe that's accurate. Correct, Ms. Wagner?
That's accurate. I wouldn't say that the warrant request is related to the current files, but Ms. Underwood understandably wants to know what's going to happen with that before we move forward in this case.
So next week will be March 6th. I'll set it for March 6th at 8:15.
Thank you, Your Honor.
Thank you, Judge.
Okay, Mr. Verlinde, you can let the officer that's with you know that you are done with court for today.
Anyway, I can get a breakout with my lawyer still, and I haven't been able to.
Yeah, I can do that.
Your Honor, the only thing I have possibly left is I was going to take care of Mr. Madrid for Mr. Malero.
Okay.
But I could break out with Mr. Verlinde briefly if the court has time.
Is Mr. Well, I don't have another. We're not.
Oh, okay. Kevin, can I Zoom with you later?
Yeah, no, I can put you in a breakout room now. I thought we had Mr. Madrid still, but we do not. So we're gonna have to call the jail for him. So I can put you in a breakout session right now.
Thank you.
I just sent a email to the jail regarding Mr. Madrid, so hopefully they'll have him back here in a minute or two.
Yes, Your Honor.
Yeah, we're supposed to be, what, 30 degrees?
What was that phone call? We're just telling them we're done. Stairs.
Control. We're ready to see Michael Madrid, if you have him available.
You never did see him? He was in here 2 times and logged off, and then I logged him back on, but you didn't see him?
No, we didn't. We've been, there was some confusion about who was representing him.
Okay. All right, give me 1 minute.
Okay.
Back on for that training meeting you got here.
What time's that at?
I think at 11.
Oh, Jesus. Yeah, I see something on here.
Here's where it says. What's that? That's where it says on the ROA where you can be released from probation. And there's the rest of the ROA. Couldn't find a judgment that's set, so.
What is this on, Leo?
It's on a box.
Oh, okay, well, thank you. Enjoy it. Yeah, I understand. I'm not arguing it. It's congrats. Right, yeah.
Yeah, I must. Shoot.
Okay, Ms. Underwood, do you need a breakout session?
Just briefly, Your Honor.
Excuse me.
All right, we are on the record in file 22-20968-FH, 22-20969-FH, and 22-72-FH. People versus Michael Anthony Madrid. We're here today for hearing on alleged contempt of court for failure to appear at sentencing on October 5, 2023. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Madrid this morning, Your Honor.
Phoebe McClure, we have the people. I'm not entirely sure if we're needed or not, but just in case.
Okay, thank you. So Ms. Underwood, where do we stand with Mr. Madrid's case today?
Your Honor, Mr. Madrid has matters in district court with Mr. Malero that will probably be coming upstairs. We would ask for a 2-week adjournment, but Your Honor, is there a probation violation report in the file?
Yes, I do have one that was prepared back in October for the sentencing hearing.
Okay.
When that was set.
Okay. What we would ask, Your Honor, is a 2-week adjournment on this, Your Honor, if the court would be so kind.
Just to be clear, does he need to be sentenced on the underlying or on a probation violation?
It's a sentencing on a probation violation.
Okay,
And
I thought it was underlying. I'm sorry.
yeah. And then he failed to appear for that, so we got a contempt related to that too. So 2 weeks is going to be March 13th. So it'll be March 13th at 8:15.
Thank you, Your Honor.
All right, Mr. Madrid, you can let the officer that's with you know that you are done with court for today.
Okay, thank you, sir.
And I believe
if they're there, Mr. Madrid, can you let them know we need Mr. White Eagle next?
So White Eagle, yes, sir.
Yeah, thank you.
I believe it's my docket with you this morning, Your Honor. Thank you.
Okay, thank you, Ms. Underwood.
Judge, are you doing something else right now?
I just asked for Mr. White Eagle.
Yeah, could I discuss that with you? Just, I don't want to be necessarily on whatever, but.